Hinsdale, and off he went. Didn't have a trailer, it was just a pickup. Johnson said that they came off 164. Said they can't double park on 164. Well, apparently what he thought they were doing was taking the wood up to 164 and then stopping and throwing it in the truck. Hey, you're going to get killed just getting wood. So what's the answer? Yeah, the girls are still out there too. Yeah.
Good evening, everybody. Welcome to the Town of Waukesha Town Board meeting on February 25th, beginning at 6:30. I'd like to call the meeting to order and begin with the Pledge of Allegiance. Is there anybody that would like to volunteer to lead the pledge? I see one volunteer.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Excellent, thank you. And Madam Clerk, could you call the roll?
Supervisor Durr?
Here.
Supervisor Fisher?
Here.
Chairman Merrick?
Present.
Supervisor Radke?
Here.
Supervisor Wolf?
Here. And Madam Clerk, have we met the opens meetings law?
Yes, we have.
And we can begin with citizens' comments.
Hello again.
Good
I'm
evening.
back. 2 weeks ago, I was here to complain about the trees. I just told a few of yous, my wife made the phone calls on Friday, Monday, got to run around all day Friday, transferred different numbers. Monday, same thing. Finally, got back, transferred back to We Energies. We Energies said, we're only replacing one, maybe two poles on the corner, far corner behind Vince Ferrara's house. That's it. She asked, why are they trimming the tree? All that lane traffic back there, all the way up the hill. Said, don't know. She said, what do I have to do to find out? Good luck. That was the comments. When she comes back from St. Louis 2 weeks, she'll start making more phone calls. I won't give up on this. I put up signs, keep out, keep somebody from driving back on Hinsdale. I told you 2 weeks ago that somebody had driven back there. I had the sheriff out there, warned them, got them off. Yesterday morning, dogs wanted to go out. I kept putting it off. Finally, I got up to let them out. And as I turned on the porch lights, the deck lights, went to let the dogs out, truck drove out of behind my house. I have to, if any other things, I would have suspected he was getting wood. Yeah, that's what he's doing, that he wasn't breaking in. But the matter is, off of Hinsdale, there's nothing to keep him from driving back there, all the way up past Johnson's, past everybody else. All right? Trees, as I said 2 weeks ago, takes a long time to grow. Yesterday in the Freeman, if we all get the Freeman, there was an article in there from the letters to the editor regarding trees, valuable resource worth protecting. Trees are not only inspirational, but extremely important in the landscape. They cut those trees down. Didn't have to. Yesterday's Journal, Milwaukee Journal, same thing as what I've been saying 2 weeks ago, saying tonight. Homeowners stumped over reason for clearing trees. They're going around. How do we, and so my question to you, mine are already gone. I was talking to
Supervisor Fisher.
talking to Brian just a few minutes ago. How do we stop them from going in and just randomly cutting to trees? They're not notifying anybody. Just when they pulled up in the truck that first day, we're just going to trim trees. All right. Gee, that's a heck of a trimming. The next day they came in with 3 trucks. That night they were all done. How do we stop them?
Well, the thing is that we, your town board, has zero control over what We Energies does within their easements and their rights of way. We couldn't tell them to plant trees or cut trees down. We have zero control over We Energies within their easement. It's purely a We Energies issue.
Nobody has control over We Energies.
Within their easement, they can do as they choose.
They can do whatever they want.
Within their easements, they can.
I'll continue making phone calls.
Okay,
Thank you.
thank you.
Can I just ask a quick question? Is there still wood, cut wood still
There's
stockpiled
still one
along there?
stockpile back there. I didn't get home till late last night. And of course, I got home, let the dogs out, came here. There's still, you can drive along 164, you can still see wood piled up. Now, I don't know if they're driving up the hill. I'm just saying yesterday morning, there was a pickup truck out there. And if I had my pants on, I would have caught the guy. My dogs would have caught him if I'd been fast enough. And he doesn't want the dogs to catch him.
I'm a little bit wondering, in particular, if people are
They're trespassing.
crossing onto private property and stuff, I'm wondering if the sheriff's department can give us some additional surveillance or set up a deer camera or do something to
That'd be
deter that
something.
from
I'm
happening.
putting sides back up from the wind damage that broke them down. So I don't know. Can they read? I don't know that either. They understand? We'll find out. All right, thanks.
Thank you. Anybody else? Going once, going twice? Then we can move on to approval of the minutes from February 11th, 2016. Is there a motion?
I have two, I guess prior to make a motion, I have two things that I would like to have addressed. If you would, on the top of the last page, I think it's page 6 of 6. Under the title there, new business dash discussion and possible action, I think we need a description before that first motion of what the issue was. It looks like it looks like it pertains to the Tyler Technologies contract, but I think we need a description there, Kathy, of what that is. You see them?
Tyler Technologies?
Yeah, above it, there's no description of what that item is. It's just the motion. And the other thing that I would ask on the one immediately above it about the weight limit ordinance, where there was a motion that failed. I guess I would like to see the motion reflect, particularly when they are motions that fail in particular or motions that are not unanimous. I guess I would like to see on that the vote was 2-2 or whatever it was, and the members of the board who voted aye and voted nay. I think that would be an important part of the record to have unless anyone objects.
So you want all of our votes now to be roll call?
No,
Well, that's what, if we're going to identify who votes which way, all of our votes are going to be roll call.
well, I don't know that that's necessarily so, but I mean, if it's a 2-2, somebody certainly knew how people voted on that, or otherwise you wouldn't be able to declare it a failed motion.
Wasn't that the definition of a roll call vote, identifying who votes which way?
I don't
I mean,
think
we
so.
haven't done that since I've been on the board.
I don't think that's necessary to record what it is. Doesn't have to be a roll call vote to simply indicate who voted aye and who voted nay. Doesn't have to be roll call.
Are you asking for that only in the cases when it is not a unanimous vote?
I think that is the most important place for it, yes. And I think that's pretty standard procedure in other municipalities and that type of thing. I think it's important on that to identify the people who voted aye and the people who voted nay.
I'm not necessarily disagreeing. I'm just trying to understand how is that different than a roll call vote?
Because the clerk can certainly identify the people who voted aye and voted nay and record it in the minutes.
If we're going to identify how each person votes, we need to have a roll call vote, in my opinion.
Well, I disagree. But more
So
important
we
to me, I think it needs to be identified. It needs to be identified. If people go back to the minutes,
It's probably a discussion for
it
another
should
day, but
reflect how people voted.
In this instance, I think we know how everybody voted, so if you would just record those, I think that would be fine, and then we could move on.
Well, my point, and I'll let it be, we may know how people voted. How does anybody else know?
I understand.
That's the point.
I get your point. Anybody else on the minutes? Can we get a motion?
Well, with these changes, let's put it over until the next meeting. My motion would be to table the minutes to the next meeting.
Is there a second? No second to table?
Okay?
Is there a motion to approve the minutes with the changes?
Also move.
And a second?
I'll second.
Any discussion? All in favor?
Aye.
Opposed?
Aye.
Abstain. Just
Yeah,
in case
and
we're
Larry
not-
isn't here. For the record, could we make sure we put Mike down as?
No, I understand.
I'll fully support that.
I just don't understand how it's different than a roll call vote, that's all.
Fair enough. Let's move on to 6, current business, discussion and possible action on the following. Tyler Technologies contract renewal. You all have Attorney Macy's comments on the new contract that Tyler Technologies snuck on us. He's got substantial changes in there. We were forewarned from the Tyler Technologies folks that we should show this to our attorney because of the changes that were in there. Attorney Macy did have brief comments that perhaps we could approve this with changes in a form acceptable to the town council, if the board would be willing to do that. Additionally, it could only be a 3-year contract as state law governs how many years we can go out with this particular contract.
I spoke with Tyler Technologies, and they were willing to keep the price at the $25,000 for the 3 years as well.
So has Tyler Technologies seen the recommended changes by the attorney?
Mark has not. I did give some to.
No, we have a representative.
Yeah, let's let Marty
did you
Keen
send
is
a
with
copy to
Tyler
Mark?
Technologies.
Yeah, I just, coming for tonight's meeting was the first that I seen it. I know that our company working across the country tries to standardize, and that's why the difference in the form was made. I take a look at these, and my opinion, I'm not the lawyer on the staff, but in my opinion, I don't think that it's an issue, and I will share this with Mark, who will share it with our staff. We can incorporate those, or if anything else, have discussions if there's something that presents a roadblock or presents an issue.
Okay. Do you know in other communities that have voiced concern about the contracts, were they similar concerns? And was Tyler Technologies able to remedy those concerns?
Yeah, I mean, we've taken on a new client, a brand new client. They've had no issues with the contract. Most recently, Village of Whitefish Bay, they signed with us last year. They had no issues with the form that was there. So again, we're doing those one at a time, though, 1 year. So not to go past multiple years. But the clients, we've gotten no negative feedback. So we can definitely share these concerns with our staff and report back to you what the status is.
Thank you. Anybody have any questions for Marty? And how would you guys like to proceed?
Well, I guess, is it prudent that we make a motion that we send this on to Marty and his crew to review?
Yes, for them to review, and that the form of the contract is acceptable to Attorney Macy, that we can sign the contract as long as it is in a form acceptable to the council.
Well, then I'll make that motion.
And a second,
I'll second.
further discussion?
I think given the nature and this, what I consider fairly significant changes to the contract, I'd prefer to see it again before we approved it. That would be my preference.
Okay.
As opposed to just upon the approval of the attorney.
Supervisor
That
Fisher?
would be my preference as well.
So call a motion.
I can amend my motion to say, subject to final approval by the board.
Okay, so then it's not going to be in a form just acceptable by the town attorney. It would be, you want to bring it back to the board. You want to table this until the next meeting, so that until the attorneys from Tyler and our attorney have had a chance to go back and forth with this?
Yeah, I think that's probably the best, because if it needs to come back, there's no reason to really make a motion. Right.
Why don't we just make this clean and call the question on the motion? And if it doesn't pass, move on.
And then table it to the next.
I am withdrawing my motion.
And Larry, are you withdrawing your second?
Yes, I am.
Okay. Is there a motion to table to the next date certain of the next meeting?
I will make a motion that we table this to the next meeting.
And a second.
I'll second.
All in favor?
Aye.
Opposed? Motion carries.
Thank you, gentlemen.
Thanks, Marty. On to the weight limit ordinance. This was brought back from the last regular meeting. You've got some recommendations from Jerry Nolan. Roads that he would like to see weight limits on and what current signages are on those roads. Supervisor Radke had a thought that perhaps rather than these roads being posted as no trucking, they should be posted as no through trucking, and brought into section F on page 3. And that's what we're really concerned about, is the through trucking, not anything being delivered to a particular resident or business, but rather using those as cut throughs.
So what you're saying, you want to move this table to under F?
Yes, with some modifications also. For instance, Jerry took off, starting at the beginning, Cambridge, he did take off Big Bend, but I would like to leave that on there. Kensington, Merrimack Trail, Morningside, Oak Grove Lane, Pheasant Run, and Sun Valley. The reason behind a number of these were trucks that were a trucking company. A guy might be living on, for instance, on Kensington and Merrimack, both of those for sure. Those were put in place because there were residents that were living there with a quad axle and running up and down those roads. That's the reason those were put there. That issue doesn't exist on some of those smaller roads any longer, and they could be removed. It is primarily the through trucking that's our concern.
So till we find out which ones we want to remove from that list, does it pay to do anything with the ordinance period?
From my perspective, I would say take everything except for Kensington, Merrimack, Morningside, Oak Grove, Pheasant Run, Sun Valley, and Cambridge, and move that entire list to no through trucking, because that is, sure, I'm sorry, I went a little fast. Cambridge, Kensington,
Well,
Merrimack, Morningside, Oak Grove, Pheasant Run, and Sun Valley.
Those are coming off in their entirety?
Correct. And the balance of those roads would go into F, no through trucking.
now, are the balance of those roads on Jerry's list also? Is it a duplicate list, or does Jerry have more than that?
Jerry does not have more than that. He also does not have Big Bend, which I disagree with.
I just went through that, Supervisor, and it appears that everything on Jerry's list is on this list.
Yes.
Okay, now that we removed the ones the chairman mentioned, the rest of them are on Jerry's list.
Right. Everything on Jerry's list, even after the ones that the chairman mentioned,
Are still
are
on.
still on.
Okay,
That's what I just went through.
okay. So you're looking to remove them from section 1B to, what is it, F?
F. Yep.
Okay, just F period, okay.
No. Uh, Jerry was talking about removing number 1 on F, no trucking on Wesley Drive.
Items 8 and 9, green country, I'm sorry. Nothing. Jerry has listed Green Lane in its entirety. And the ordinance currently is worded as Green Lane beginning 1/10 of a mile west of intersection with Merrill Hills Road, County Trunk TT, and proceeding westerly to Sunset Drive, County Trunk D. So right now, the ordinance says that the first 1/10 of a mile from Merrill Hills Road west, it would be permitted. Yeah, that's,
Is that
And I
where that contractor lives, that
Yes.
first house behind the church?
And I think that's what was written specifically for that, and perhaps, yes, as Jerry's got it in its entirety.
so we do want Green Lane in its entirety? Is that what we're
I
saying?
would say yes.
Okay. And how is the current existing business that's on that road going to be affected?
As long as they're going to and from that business.
It's a
Oh, because
destination.
it's not a through trucking.
Yes.
Thank you. Supervisor Radke, you were passionate about this 2 weeks ago. You got any thoughts?
I have no reason to revisit it.
Okay.
I think it's full of a lot of controversy. I would agree, as I told the chairman, that no through trucking makes more sense than prohibited trucking. I do believe, though, that there is a statute in the state that says you can designate all your streets as no through trucking other than the heavy truck routes. So instead of just pencil whipping this through and relying on some comments from several people, I think some thought should really go into it instead of just pushing this through. But there's an ordinance 34917 from the Wisconsin statutes that states it authorizes a city or village to prohibit heavy traffic from using any street or alley which has not been designated as a heavy truck route, unless such street is being used to obtain orders for supplies or deliver supplies or commodities to or from a place of business or residence. That might be easier.
Perhaps we've got Captain Larsul from the Waukesha County Sheriff's Department back there, and she did help us when we were talking about putting weight limits on roads and what we needed to do. Captain, would you want to weigh in on this? Do you have any input on 34917?
I just took note of the statute that you brought up. I would have to actually look it up in its entirety and actually go through it first.
Okay.
We have to put up signs for heavy traffic, trucking around.
No, but I believe in order to cite anyone, you would need signs, so you may want them at particular roads that are of a concern.
When we met with the Sheriff's Department, there were very specific requirements regarding signage, where it had to be, how big it had to be, the letters, so on and so forth. So in that case, in the case of what you're talking about, no through trucking on all of the roads, it would seem to me that we'd have to post every road.
Doesn't appear that way, but again, I haven't done a ton of research on that. It just seemed like that could be an option. If the concern truly is the deterioration of our roads, then wouldn't we want to limit most of them, if not all of them?
Captain Marcel, you aware of that in any other communities that you service?
No.
Okay. Would we like to set this aside and allow the Sheriff's Department to investigate that a little bit further and find out what we would have to do in order to have that on all roads? Supervisor Fisher?
Just so that I'm clear too, we're talking about permanent.
Yes,
We're talking about.
not
permanent
seasonal.
signage.
Correct,
Right, not seasonal, permanent.
correct.
Okay.
Yeah, seasonal has its own section that, we don't need any revision to that. That's at the discretion of the DPW and or the town board as to roads that are under the spring thaw.
I don't think that we are in a position to move ahead with this tonight in order to try to get this right. I think there are too many things that are that are in the air. I mean, I look at Jerry's list here, and for example, he's got Arlo Drive and Crestview Drive in their entirety for construction traffic. And I mean, maybe there's a good reason for that. Is he thinking somebody's using those for access to those areas south of there that haven't been built out or whatever? I mean, there's just so many, from my perspective, questions in mind, or questions in my mind with this. I guess I would think also that really we need to look at what the signage would be, so there's some consistency to it. I mean, I think if we're gonna revise this ordinance, it looks to me as though every bit of the current signage probably goes to the dump. And we're starting over. I mean, it doesn't make much sense to me to repeal and reenact an ordinance if we're not going to put up signage. I guess I would like to see what the verbiage on that signage is going to be, so it in effect accomplishes what our ordinance says. I think the other part that we really need to take a look at, it is difficult or confusing for me. I mean, I took the copy we've got in the packet tonight, and I know we looked at this back, I think, on the 12th of November, and we pushed it aside, but I look, even the draft we've got tonight, I reprinted what's in the ordinance now, and I'm trying to go back and forth. I think even if you look at page 2, at the least, we got to do some reformatting of this, because item D in the middle of page 2 is special and seasonal weight limitations. And then it goes with sub letters underneath that. I think probably that exemption for vehicles is really supposed to be paragraph E or whatever. And I just don't think it's well thought out. I think we have an awful lot of conflicting expectations about this. I think there's a lot of confusion. I think we need to really dial this thing back and get it right. So I can't support moving ahead with it tonight.
Would you then make a motion to table to a date certain?
Sure, and I will do that, and then as soon as a motion is made, I think discussion stops. I think maybe the better thing would be, and I'm trying to be constructive about it, I was not in favor of this last meeting, but I think we need to kind of find a way forward so that the next time this comes back, at least the thing is cleaner in terms of what the intention is. So I mean, we make that motion, but I think we ought to try to get some sense on what we're really trying to accomplish.
All right, so are you advocating then you'd like to tell us what changes you'd like to the document?
Well, I think I've indicated some of the concerns I've got about it. Again, I'm not exactly sure what it is that we are trying to accomplish. If it's trying to, I mean, I think we've made some step in the right direction. If we are trying to eliminate through truck traffic,
Yes.
is that everybody's expectation? Then I think this sure looks different than what's before us at this point in time.
Okay, and give me some, we've got to give the clerk some direction on what needs to be changed.
Well, I think we started on that, but again, I mean, the thing in our packet here and the thing that's been presented to citizens, and anybody who looks at it, there's 22 streets on there. We've got a thing with Jerry here that he's cut that back, and we're talking about stuff. I mean, I just think that somebody needs to spend some time and put this together and present it in a more organized fashion. And I just, before it actually comes to discussion, I think we got to have a clearer vision of what we're trying to do and get the thing cleaned up.
It kind of sounds to me like you're volunteering to do that.
No, not so much. I'm the least knowledgeable person about this topic at the board, so I'm not.
So we're gonna go with, we're trying to eliminate our through truck traffic. Make sure that I format it so it's one and then ABC. Other than that, we're looking at 349.17 to see how it's worded,
If that applies.
if it applies.
And Supervisor Fisher, you had mentioned that perhaps B, exemption of vehicles carrying certain commodities, should be E instead.
I'm wondering, it would make more sense.
How? So we have section 1, A, B, C, D, and then D, A, B, D, B, I, and then D, C.
So formatting.
I mean, I guess I
No,
don't.
I'm trying to understand what your
Sure,
conflict
sure. I
on
mean,
the format
if you
is.
go back and look at the ordinance that exists now, correct me if I'm wrong, but I don't think, and again, let me, I guess, back up for a minute. I think this would be a whole lot easier to understand and read if we had the ordinances that now exists and we basically had these as track changes. Then it would be more understandable. And I think, isn't D sub B, I think that's new verbiage. Is that a recitation of state statutes? Is that what that is, or?
Yeah, that's what it's talking about.
Yeah.
349.16.
But I mean, my reading of it, what's now D sub B, if we put this together, this exemption applies to the heavy vehicle prohibition B as well, doesn't it? So it shouldn't just be under D. I mean, that's what's confusing to me. Aren't those exceptions or exemptions, those exemptions apply as well to the heavy trucking part of it, don't they? I mean, I think that stands alone. That shouldn't be under the special and seasonal weight limitations, I don't think.
I could,
It would make
I
more
could get on
sense.
board with that, yes.
Make more sense, I think.
Anybody else? Motion to table this to a date certain of the next meeting?
Second.
I was asking if there was a motion, but I'll make that motion.
There you go.
All in favor?
Aye.
Opposed?
Aye.
Motion carries. On to 7, new business, discussion and possible action on the following. Chad Vendette, extension request for non-compliance at South 35 West 27650 Country Club Court. I think Mr. Vendette is in the audience here tonight. This is revolves around a temporary structure housing his son's car, I believe, correct?
That's correct.
Good evening.
Good evening. My first appearance here, so first I'll start by saying thank you to the board for all the work you do on behalf of the citizens and the town. I'm sure at some points it seems like an unsung effort, but it's certainly appreciated. So I'll start there. This is my first appearance here and hopefully my only. I will.
I said that once too, and I'm sitting on this
Yeah,
side.
now you're on the board. That's funny. My next question to the board is, why am I here? I received a letter from the town, from Safe Built, in regards to zoning code section 13-2-3A, which references a permanent structure. My structure is not a permanent structure. So I was cited on something that's not applicable to my situation or an alleged infraction. So I asked, why am I here? I looked up the statute and it definitely doesn't apply. So I called the town and asked that same question, why did I receive this letter? And it was suggested I meet with the planner And I made an appointment to do that just last week. And in doing such, I met with the planner, and he had indicated the same thing to me. Well, he looked up the statute, said, well, that doesn't apply. And then looked up said, well, I showed him what the structure was. I have a picture for you if you wish to see it. And he said oh, well, it's a temporary structure. And he looked up, tapped on his laptop, looked up the temporary structure statute, and then called the code officer over from Safe Built and expressed to him what the issue was. And the code officer indicated he was willing to issue a permit for the structure. That's what he said in the meeting. The planner said, well, I'm not so sure you can do that. And he cited some other instance, but the code officer says that didn't apply because that was a much larger structure and it was 600 square feet or something, and it had to meet some permanent wind load. And so he said there wasn't an apples to apples comparison. And he again offered to, or indicated he could issue a permit for the structure. He was then stopped by the planner, who said, basically, I don't think you can do that. The board doesn't like these, or something such to that. He said, yeah, the board doesn't like them. I don't know if you like them or not, but that's what he said. And then they suggested that I meet with the board, which is why I'm here this evening to answer my own question from the beginning. I don't think I'll be sitting on that side anytime soon, but at least. So I looked up the ordinance, and I looked at it very closely. The ordinance for a temporary structure, I believe, is inclusive of my structure, and I'll get to why in a moment. And I believe that it's being enforced very narrowly. From what I can read in the ordinances, they were first issued in 1948, amended in 1956, and then in 1979. I'm guessing this was probably written in 48 or maybe 56. I don't know how that particular works, but I also believe that the writers of these ordinances could not have envisioned every type of structure that would have happened from 1948 to 2016. So I believe they kept the ordinance somewhat broad to be inclusive of a temporary structure, which this is most certainly is a temporary structure. It goes up in about an hour. And there's no foundation. In fact, I have a photo if you wish to see it.
We have them.
You have them. Okay, so you have the photos. Okay, good. So it's definitely a temporary structure. So in looking at so now I have discord or conflict between two town officials. One saying I can't have it because somebody doesn't like it. A code officer who's saying he can issue a permit for it twice, and he was fairly insistent that he could until he was essentially shut down by the planner, is the way I got it. So I have the discord between, I guess, the board, me as a property owner with property rights, the planner, and the code official. So I have all of that. If I go to the particular ordinance, it says,
Well, what was the ordinance number that I had an opportunity to talk with Mr. Van Dett last week, and we went through that. It was a 13.2.
It was, bear with me, 13.2-8E, I think is what says temporary uses.
Okay, let's just pull it up.
Page 26. And in temporary uses, I'll read it as it says, temporary uses. Temporary uses such as real estate sales field offices, comma, shelters for materials and equipment being used in the construction of a permanent structure, comma, or living unit in conjunction with constructing a dwelling, comma, shall be permitted provided that such use is not contrary to the intent of the ordinance. The town board shall review and issue a permit if they find that temporary use meets the intent of this ordinance. Such permit shall be valid for a period of 6 months, may be renewable for one additional 6-month period, and then it has to see section 13-2-17. So I went to the temporary structure description on page 7 of 13-1-4 introduction. Temporary structure. A movable structure not designed for human habitation or occupancy, but for temporary protection of goods or chattel during a period of construction, comma, but not to exceed 1 year, comma, for the enclosure or screening of goods or property, semicolon, or for the display of signs and advertising. I believe if you go back to my original 13-2-8E, that covers temporary use of an item. And I'll get to what my temporary use is in a minute. And then if you look at the description of a temporary structure, you have what I see as several different categories, such as by definition means an example thereof, not specific, but it's inclusive of types of things. And then I see several types of things here. One is a movable structure not designed for human habitation. Excuse me, picked up the wrong one. Temporary uses such as real estate, sales, field office. That's certainly a very different thing. I don't know what they do at real estate sales, field office. I'm not in that business, but they do something, I guess, out in the field that requires it to be in place for a certain period of time.
That was the structure that they would put up when they were selling lots in a subdivision.
Okay, but that's a very narrow focus.
No, I understand, but you're asking what a temporary real estate sales.
I appreciate the description, but it also could be a remote site. It could. I've seen tents that people put up, and they give away flyers. They're outside of malls. They do all sorts of things. That I've seen that. Shelter. Then it goes on to say shelters for materials and equipment being used in the construction, permanent structure or living unit, etc. Then if I go back to where I was previously at the temporary structure, this is where I believe that the temporary structure, I fall into the statute. It talks about a movable structure not designed for human habitation or occupancy, but for the temporary protection of goods or chattel during a period of construction, comma, separate thought, goods or chattels. I don't think anybody says chattels anymore, but I guess they did in 1948. Sounds like livestock. But not to exceed 1 year. Then it goes on again and says for the enclosure or screening of goods or property. So they've used goods twice in here. So I see for enclosure or screening of goods or property as a separate thought by the original intent of the ordinance.
And for my edification, can you tell me where you're reading the exact code section?
That's 13-1-4 introduction. Number 82, page 7 of that section. It is a
13-4.
13-1.
13-1. Okay.
And it's number 82 on page 7. And what this is it's a description of what a temporary structure is used for or what it might be for. And they've used the word goods twice in here in two separate thoughts, and goods are property. So the way I see it is that this ordinance is for temporary structures, could be for different ideas or different reasons why you may need a temporary structure. And one of the descriptions of what a temporary structure is for the enclosure or screening of goods or property. I'm using this and I'll get to my use in a minute, or now I guess you'd say, as a temporary shelter, I should say, or structure for my son's vehicle who goes to college and goes to work, and he graduates next year. And he needs a place to put his car that's not covered with snow when he's going to work in his work clothes and has to shovel the snow off in his nice work shoes.
Okay, I want to go backwards for a moment. I'm in 13-1-4, and you were reading out of which?
Page 7, number 82, description of temporary structure.
So that says, a movable structure not designed for human habitation or occupancy, but for the temporary protection of goods or chattels during the period of construction. I mean, you're not in the period of construction, are you?
At this point, no.
Okay.
But it is a movable structure not designed for human habitation, so that segment does apply.
The sentence says, a movable structure not designed for human habitation or occupancy, but for the temporary protection of goods and chattels during the period of construction. So this wouldn't apply to you if you're not in a period of construction.
Keep reading.
I understand, but not to exceed 1 year for the enclosure of screening of goods or property or the display of signs or for the display of signs and advertising. That's all one sentence.
Well, there's commas in there.
I
and they
understand
use
there's
goods.
commas, but it's all one sentence. And it all pertain, in my mind and in my reading, and I'm not an attorney and I won't play one on the town board, but my interpretation of that would be that that all pertains to the period of construction.
Well, what that would say is then that there's no temporary structures at all ever allowed in the town for any reason, if you read it that way. That you could
No.
never have a
No, no,
temporary
no, no, no.
structure.
You
unless
can if
it-
you're in the period of
Unless it
construction.
was for construction. That's the only reason you're allowed to have a temporary structure. So I can't put up a tent in my backyard. I can't have a party. You can't have those Costco tents we see that are around town sometimes where they're giving away flyers so you can sign up for Costco. So that's a really narrow focus of this ordinance. And it would seem to me that in 1948, there was no such thing as this type of garage. And they may have written this particular ordinance to be inclusive thereof, of the types of things, because they do use in a separate, although in the same sentence with a comma, they use the term goods twice. So why would they, if they've used it once and that satisfies goods, why would they then go on to say for the enclosure or screening of goods or property as a separate segment of that sentence?
Just a bit of background to this, I mean, a couple of quick things. We're not going to resolve tonight, but if we are having mixed signals being sent by building inspection and planning, then we need to have that discussion with them so that things are being interpreted consistently and information provided. We're not going to resolve that tonight.
Sure.
I would tell you, we have had discussions on this in the past in the context of two different things as to what the definition of a structure is. Okay. And without gentlemen looking at the ordinance, I can tell you that I believe in recent history, these types of tent type structures, I will tell you, we have considered and find those to be structures. Okay. There are a lot of instances in the past, and these are often in commercial applications, but people over at Walmart, even when the grocery store and Kohl's and so forth was over here on Sunset, I mean, a number of instances, they would come and get permits for temporary structures for specific durations of time, if they were doing flower sales or garden sales or whatever. So don't want you to walk away tonight with the thought that the town does not permit that type of activity at all. But usually there's been a permit, there's been a request, there's been a discussion of that. The issue that it comes in looking at a photograph of what you got here, again, you're not doing construction or whatever, and certainly take you at your word that can be put up in an hour. But the concern from the town's perspective is temporary isn't about how long it takes you to put it up, but how long it might be there. If this is fairly durable, what's to prevent it to be there from being there for 2 years, 3 years, 4 years, 5 years? That certainly is not the definition of temporary. So I don't know if that provides any context to it, but the purpose of the ordinance, we have to look at the way it's being enforced and so forth. Definitionally, it's a structure, but the issue of temporary, I mean, if somebody comes up and says, hey, I need this thing for a short duration or what or not, I think that might be given favorable consideration from the town. But when it's something for which there's no limit to duration of time, it defies the definition of a temporary structure, in my opinion.
And that's a fair assessment. And therein lies with what I'm asking from the town is for the, as written in here, for the 6-month permit. That's what I'm looking for. I'm not, and maybe I didn't make that clear in the beginning. I'm not here saying, listen, now this is up here and it's temporary and it's got to stay here for years, and he's not going to stay at home for years. I can guarantee you that. But sorry, but when he graduates, but I'm looking for a permit for based on this for the 6 months duration. And you said that may not be solved tonight, but that's what I'm asking for.
I'm not an attorney either, but I did have an opportunity to run this past council. And his reading is the same as my reading of that. And that is that when we look at temporary structure and the definitions on page 7, number 82, that where it says temporary protection of goods or chattels during the period of construction, comma, but not to exceed 1 year during that period of construction, comma, for the enclosure or screening of goods or property. It's all related to construction. And then if we go over to 13.2.8 sub E, again, it references construction, temporary uses such as real estate, field offices, shelters for materials and equipment being used in the construction of a permanent structure or living unit in conjunction with constructing a dwelling shall be permitted, provided the use is not contrary to the intent of the ordinance. Again, going back to construction, and then it goes, see section 13.2.17. And when we look at that, again, they're talking about a temporary structure, this one being a mobile home. Habitation is an accessory to the current construction of a principal residence. They're always going back to construction. So it's, at least to us, it was clear that this was for the purposes of construction, that it would be a temporary enclosure for construction purposes only. And that's the way that we've been reading it.
Mr. Chairman, I'm sorry.
And that's the way that that's the way that it's been enforced.
Can I just ask a pragmatic question again? On one hand, I said we're not going to resolve this tonight. We do need to come to some resolution, but in terms of bigger picture and other town residents and that type of thing, I mean, you indicated, and I see your photograph here, and I'm assuming that's a nice car inside of there, but need to protect it from snow and that type of thing. I'm ready to pronounce that February 25th winter is over and we're not getting any more snow this year. I mean, do you need that? I mean, if that's ostensibly the purpose, do you need that going forward? Why do you need it for 6 months? And I'm pushing aside from it completely with the ordinances. Why do you need it for 6 months when assuredly it's not going to snow anymore this year?
The snow is one of the reasons, clearly, for it. Is a nice car. He bought it himself and worked hard for it.
Give me another one beyond
But
snow.
the snow is one of the reasons. The other reason is to protect the vehicle from wind, rain, hail. We do get hailstorms in the spring. I think we're all familiar with that. He will graduate soon enough and then be on his way, and I won't need it any longer.
At the last meeting of this board, we did approve until May 1st. Am I correct? 2 similar structures, similar circumstances, not exactly your circumstance, but similar. I think for purposes of uniformity, we should probably look to past practices in what we've been doing.
If you want that in the form of a motion, at least so we can move the discussion ahead, I will move to allow this temporary structure to be in place until the 1st of May.
Is there a second?
I'll second it.
Any further discussion?
Well, I have just one comment. First of all, personally, and I can't speak for the board, I don't have any issue with these. It's just becoming more and more popular to the board that people are bringing it before us, and unfortunately, then we have to act. I think you probably know, if you drive through the town, you'll see several of these. And they're not all up before us, but it's rearing its ugly head, and this may force it to rewrite another ordinance that says, here's the true rules of it. I don't know.
That is a discussion perhaps for another day. And again,
Right.
I don't take issue with it, but we still are tasked with.
Enforcing the ordinance.
Right.
Yeah.
Yes.
Um,
And we talked about this previously. It is probably one of the least desirable things that we have to do when we sit up here and look at this stuff. I'm sorry.
Really?
Well, there were less desirable things in the past, but
I concur. I mean, I don't have a fundamental negative slant against these structures. I really don't. I think it's clear to me that it is, number one, a temporary structure. And number two, that our ordinance calls for temporary structures pretty much in construction activities only. And if somebody was selling Costco memberships out of a tent on a corner and it was there for 2 weeks and there was enough time for somebody to file a complaint, I would certainly concur that that would be out of line. I think, getting to a tent for a party that lasts a day, you just run out of, you don't have the logistics for that.
But it's technically, pardon me, but it's technically in violation.
And we have lots of stuff that's technically in violation, but we don't have a compliance police. We don't have people, I don't believe there's anybody on the board that actively drives around and tries to figure out people out of compliance. What we find ourselves in a situation of is when somebody brings us a complaint and the complaint is filed in writing and submitted to us, then we're, required to act on it. But we don't have a compliance police. I think some residents think that we do and we don't. But so there's a motion on the table to extend it to March 1st, or excuse me, to May 1st. Do you see yourself bringing this down by May 1st or after May 1st?
Well, what I was asking for was 6 months.
Well, I understand, but the motion is for May 1st. Currently, right. But I'm asking as a person who's going to vote on that motion, do you see yourself having it down on May 2nd?
I don't understand the question. If I'm ordered by the town to take it down by May 1st, are you saying, will I violate that order? Is that what you're asking me?
Is that going to work for you?
My answer would be no, because I asked for
okay.
6 months.
Okay, I understand. Thank you.
So,
That's all I was asking.
And the reason that we're at that point is because there needs to be some consistency with the things that we do. And I mean, just 2 weeks ago, that's exactly where we're at with two other very similar circumstances, similar structures.
mm-hmm. Did your town attorney happen to look at the very last part of the 13-1-482 on the description of temporary structure, the very last part of that sentence separated by a semicolon?
That was the one on page 7,
Yeah,
right?
for the display of signs and advertising.
Semicolons legally are a separate thought in the description.
Agreed, but again, this is all related to construction and all related to temporary signage and that semicolon for the display of signs and advertising.
Mm-hmm.
That's not, that again is separate from what you're doing. So yes, we had an in-depth discussion about this and kept returning to that this is about construction activities and storage of materials for construction, storage of signage, temporary selling facilities. Brian?
Well, yeah, just one last comment. We're going to vote in a bit. I'm going to support the motion for May 1st. I think that's fair and reasonable with what we have done. We dealt with the same issue with two other Finetown residents 2 weeks ago. I can't go beyond that. I mean, if you really take the big picture view of it, yes, we've got some homework to do, go and revisit it, but nobody knows looking at that photograph whether there's a Lamborghini or scrap metal in there. I mean, that's the big picture from the town point of view. We can't, I don't think in good conscience tonight, grant you 6 months. If we're going to do that, then we might as well ask the people who were 2 weeks here 2 weeks ago to come back in and extend the same amount of grace to them. So I understand issues about semicolons and that type of thing, but we're trying to do something I think that's pragmatic and fair here. Do we have some homework to do to clarify this and get consistent signals sent? Sure, but I'll support that motion tonight and nothing more.
You said it was 2 weeks ago that the other folks were here? So I'm shorted 2 weeks then because they got their time 2 weeks ago. Now I'm given 2 weeks shorter time.
No, you've had it up just as long. You've had it up just as long.
That's unknown for them or me.
Okay.
All of you are on the same complaint. So it's just that some came in earlier than you did.
I still feel I'm shorted 2 weeks, but
Anything further? All in favor?
Aye.
Opposed? Motion carries. Thank you. I do appreciate your time.
I'll be back.
On to 8, accounts payable, authorized payment of the bills in the amount of $45,575.73.
I'll make a motion, we pay the bills in that amount.
And a second?
Second.
All in favor? Opposed? Motion carries. On to 9, is there a motion for adjournment?
I'll make a motion that we adjourn.
And a second?
Second.
All in favor? Aye. Opposed? We are adjourned. Thank you.